Imagine a country as vast and, well, culturally intricate as India. How does such a nation govern its most unique communities, especially those in remote or tribal areas?
Yeah, communities that have sometimes maintained ancient traditions for millennia. It's a huge question.
It really is. How do you strike that incredibly delicate balance, between national unity and the profound necessity of preserving unique cultures, customs, ways of life?
That question truly gets right to the heart of it, doesn't it? What it
Yeah.
means to be a truly diverse democracy.
Sure.
One that aims for, well, not homogeneity, but harmonious coexistence.
Right.
And what's fascinating is how precisely, how thoughtfully the Indian Constitution actually addresses this very challenge. It shows this deep commitment right from the start.
Absolutely. So today we're embarking on a deep dive into a really fascinating, though maybe often overlooked aspect of India's constitutional framework.
hmm
The special provisions specifically designed for what are called scheduled areas and tribal areas.
And this isn't just, drawing lines on a map, not just administrative convenience.
No, not at all. This is about deeply considered bespoke governance models, meticulously tailored for specific communities, recognizing their distinct historical, social, economic, and crucially, their cultural realities.
It's a powerful testament, really, to the idea that one size just doesn't fit all. Can't fit all in a country like India.
So where are we getting our information for this deep dive?
Our main source today is Indian Polity by M. Laxmikanth, which is, well, it's widely seen as the definitive text on the Indian Constitution and its administrative framework.
Essential reading, for sure.
Absolutely. If you're serious about understanding Indian governance, you need Laxmikanth.
Hmm.
And this text lays out the intricate details found within Article 244, that's in Part X of the Constitution.
Okay, Article 244, Part X.
And we're going to unpack the two schedules that flow from that.
Yeah,
Fifth and sixth schedules. We'll dig into the why are these areas treated so differently.
and explore the mechanisms, right? The actual structures put in place for administration, welfare, protection.
Exactly. Ensuring their effective administration and ultimately the welfare and self-determination of the people living there.
So think of this as your shortcut, your guide to understanding a nuanced and absolutely essential part of Indian governance.
It's a system full of surprising facts, actually, about self-rule on one hand and central oversight on the other.
All designed to protect, uplift, and empower some of India's most distinct populations. It shows this really dynamic interplay, doesn't it? Power and responsibility across federal lines.
All with the goal of fostering equity and preserving identity.
So let's get ready to explore this intricate system. Uncover the layers of wisdom embedded in its design.
Okay, so to really grasp this unique aspect of Indian governance, we need to start with the foundation, the philosophy behind it.
Right.
The very existence of scheduled areas and tribal areas under a special system, it reveals something profound about India's approach to diversity, doesn't it?
It absolutely does. It signals right away that India's governance isn't a rigid, one-size-fits-all model aimed at uniformity. No. This intricate system starts its constitutional life with Article 244. You mentioned that. In Part X, that's the bedrock.
That's the bedrock. And what's really fascinating here is that this isn't just an administrative carve-out. It's not just bureaucratic lines.
Right.
It signals a deep constitutional recognition that certain populations, certain geographies within India need a significant departure from, let's say, conventional state governance
So it highlights the complexity straight away.
immediately. Governing a nation as incredibly diverse as India, a uniform application of laws and administration might not always serve the best interests of all communities.
Especially those with unique social structures or economic vulnerabilities or distinct cultures.
Precisely. So Article 244 is, in essence, it's a constitutional blueprint for differentiated governance.
And right from that article, this constitutional mandate splits. It branches into two remarkably distinct paths, the fifth schedule and the sixth schedule.
Two different paths.
And the distinction between them is fundamental. It tells us a lot about the different challenges, the different objectives the Constitution was trying to address.
Absolutely.
So the fifth schedule, this one's broader, right? Geographically broader.
Yes, much broader. It's designed to cover the administration and control of scheduled areas and scheduled tribes in any state across India.
Any state. But there's a big exception.
A very significant and deliberate exception, yes. The four northeastern states, Assam, Meghalaya, Tripura, and Mizoram. They are excluded from the Fifth Schedule's general application.
And that exception itself hints that something different is needed there, a more specialized approach for that region.
Exactly. And that brings us to the core rationale for this split between the Fifth and Sixth Schedules. Why the difference?
Okay, let's break that down. The Fifth Schedule areas, why are they special?
Well, our source, Laxmikanth, tells us these areas are primarily inhabited by what it terms aboriginals. That's the historical constitutional term for indigenous tribal populations.
Oh.
And they're described as being socially and economically rather backward.
Rather backward. That's a direct quote.
Yes. And it's not just a description. It's the constitutional recognition that these communities face specific disadvantages, and therefore special efforts need to be made to improve their condition.
So it's explicitly stating why a special system is needed. It's about disadvantage and the need for special efforts.
Precisely. The underlying assumption is that the, quote, normal administrative machinery operating in a typical state might be ill-equipped or maybe even inappropriate for these specific communities.
Given their unique social structures, economic vulnerabilities, maybe remote locations.
All of that. So the Fifth Schedule is really about providing a protective and developmental framework.
So acknowledging a historical disparity, taking active steps to bridge that gap, to uplift these communities while respecting their, existing social frameworks.
Yes, and because of this recognized backwardness and the need for focused development, the central government actually takes on somewhat greater responsibility for these areas.
Ah, so it's not just left to the states. The center steps in more directly.
A bit more directly, yes. It indicates a shared responsibility, a higher level of central oversight to make sure the constitutional goals are met.
And just to give people a picture, how widespread is this? Which states have these Fifth Schedule areas?
Currently, there are 10 states, so it's quite significant. You have Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan.
Wow, okay, that's a wide swath of the country. Really highlights how important these provisions are across different regions.
Definitely. It covers a significant portion of India's diverse landscape.
Now let's contrast that with the Sixth Schedule. You said it provides a stark contrast.
It really does. It highlights a fundamentally different rationale. This schedule deals specifically with the administration of tribal areas in just those 4 northeastern states we mentioned: Assam, Meghalaya, Tripura, and Mizoram.
Okay, only those 4. And the reason, it's not primarily economic backwardness here.
Not primarily, no, though that might exist too. The profound reason, according to the source, is rooted in a different set of historical, social, and cultural realities.
And this is where it gets really compelling, because Laxmikanth explicitly states the tribes in Assam, Meghalaya, Tripura, and Mizoram have not assimilated much the life and ways of the other people in these states.
That's the crucial distinction. Not assimilated much.
It signals the core concern isn't just economic upliftment. It's about recognizing and preserving a profound cultural difference, a historical path of non-assimilation.
Yes. It speaks to a deep-seated desire, constitutionally enshrined, to protect unique cultural identities.
The source uses a pretty striking phrase, too, doesn't it? About anthropological specimens.
It does. These areas have hitherto been anthropological specimens. Now, that's a historical term, and in its original context, it was meant to underscore their unique cultural integrity, their isolation, the extent to which they'd remain distinct.
Right. Not meant pejoratively in that context, but descriptively of their distinctness.
Exactly. And it draws a sharp contrast with tribal people in other parts of India who, as the source notes, have more or less adopted the culture of the majority of the people in whose midst they live.
So that highlights the really distinct cultural path of these northeastern tribes, emphasizing they still have their roots in their own culture, customs, and civilization.
Right. It's not about their capacity to assimilate or lack thereof. It's about recognizing their unique identity and the constitutional commitment to preserve it.
So because of this deep-rooted, distinct cultural identity, which sets them apart even within their own states, the Constitution treats them differently.
Fundamentally differently.
Cultural preservation, not just welfare, becomes a primary driver. And what does that mean for governance?
It means, and this is key for the Sixth Schedule, a sizable amount of autonomy has been given to these people for self-government.
Autonomy for self-government.
Yes. This sets the stage for a much more robust, far-reaching form of self-governance under the Sixth Schedule. It acknowledges that protecting a culture often means empowering that culture to govern itself, to maintain its traditions, decide its own path.
Okay, let's really zoom in now on the Fifth Schedule. How are these scheduled areas actually administered? You mentioned the center has greater responsibility. Where does that start?
It starts right at the top with the President of India. The President holds a truly pivotal, singular role in declaring these areas.
Ah, so it's not a state decision, it's central,
We-
presidential.
Exactly. It underscores the Union government's overarching responsibility. The President, and only the President, is empowered to declare an area as a scheduled area. This highlights the national importance placed on these regions.
And is that declaration set in stone? Or can it change?
That's what's particularly fascinating, the dynamic nature of this authority. Lax McCann points this out clearly. The President isn't just making a one-time declaration.
Oh.
They have significant flexibility. They can increase or decrease the area of a scheduled region. They can alter its boundary lines. They can even rescind the designation entirely if circumstances change.
Wow, okay, so they can undo it.
Yes, or make fresh orders for redesignation based on, say, evolving demographics or needs over time. It shows an inbuilt adaptability. It's not rigid.
But the president doesn't just do this unilaterally, right?
No, absolutely not. And this is crucial. The president must consult with the governor of the concerned state before making any such changes.
A vital check and balance ensures state-level knowledge is factored in.
Precisely. Integrate state concerns into that central decision-making.
Now, does the Constitution actually list the criteria for declaring an area scheduled?
Interestingly, no. The Constitution itself doesn't explicitly spell out the criteria.
Oh. So how does the president decide?
Well, our source tells us that certain well-established practical criteria have evolved and are consistently applied over time. These guide the president's use of this significant power.
Okay, like what? What are these criteria?
Firstly, there's the demographic aspect. A preponderance of tribal population.
Meaning a clear majority of residents must be from scheduled tribes.
Exactly. Ensures the provisions are targeted correctly.
Makes sense. What else?
Beyond demographics, there are practicalities. Geography and administration. There's the need for compactness and reasonable size of the area.
So it has to be a cohesive, manageable unit, not fragmented bits everywhere.
Right. And it also needs to be a viable administrative entity, such as a district, block, or taluk, meaning it can actually function effectively within the existing state administrative structure.
Okay. Viable administratively.
Yeah.
And the economic aspect.
Crucially, yes. Economic backwardness of the area as compared to the neighboring areas.
Ah, so that brings us back to the core rationale of the Fifth Schedule protection welfare upliftment, targeting areas needing special developmental help.
Exactly. So, while not explicitly in the Constitution text itself, these practical, well-established criteria, population, compactness, administrative viability, economic backwardness, they guide the application of this presidential power. Allows for flexibility, but a principled approach.
Got it. So once an area is declared scheduled, how do the executive powers work between the state and the center? Does the state government just step back?
Not entirely, no. Interestingly, the executive power of a state does extend to the scheduled areas within its borders.
Okay, so the state government is still involved in administration.
They are. However, there's a crucial distinctive layer here. The governor of that state has a special responsibility regarding the administration of these specific areas.
A special responsibility. What does that entail? Is it just symbolic?
No, not passive at all. It implies an active duty to oversee and ensure the special provisions are properly implemented.
And how is that oversight maintained? Especially by the center.
This special responsibility is precisely where that central oversight kicks in, creating that unique federal dynamic. The governor must submit a regular report to the president about how these areas are being administered.
A report to the president? How often?
Annually, or whenever the president specifically requests it. So there's flexibility based on perceived need.
So a direct line of information and accountability from the state governor to the president.
Exactly. It ensures accountability and transparency at the state level. And to further strengthen this, the executive power of the Union Center extends to giving directions to the states regarding the administration of scheduled areas.
Directions. So the center can actively tell the state what to do in these areas.
Yes, they can guide, influence, and even direct state actions to ensure national objectives for tribal welfare are met. It's a powerful mechanism for coordinated governance.
Moving beyond the executive, what about institutional mechanisms? Are there specific bodies set up?
Yes, a key one built directly into the Fifth Schedule is the Tribes Advisory Council, or TAC.
TAC. Okay. Is this optional?
No, it's mandatory. Each state with scheduled areas must establish a TAC,
And its purpose?
clear and focused, to advise on welfare and advancement of the scheduled tribes in those areas. Ensures administration isn't solely top-down. It incorporates a formal channel for local input.
Local input. How is it composed? Who sits on the TAC?
It consists of 20 members, and crucially, it has a significant democratic component built right in,
Oh,
3/4 of whom are to be the representatives of the scheduled tribes in the state legislative assembly.
3/4. So 15 out of 20 members are tribal MLAs from that state?
Exactly. It ensures the voices of the tribal communities themselves, through their elected officials, are strongly represented and influential in the advisory process. It helps align policies with actual needs.
That's critical. And can this TAC idea be used elsewhere, even if a state doesn't have formally declared scheduled areas?
Yes, it shows the adaptability of the framework. The source notes that a similar council can be established in a state that has scheduled tribes but no scheduled areas if the president directs it.
Interesting. So the advisory mechanism can be extended if needed.
Exactly. Demonstrates a flexible approach to addressing tribal concerns across the nation, not strictly limited to the formally declared areas.
Now, you mentioned the normal administrative machinery might not apply fully. Let's talk about laws. How does law application work here? This seems like where the unique governance really comes in.
It absolutely is. This is where you see significant deviations. Unlike other parts of a state where laws apply uniformly, the governor is specifically empowered here
Empowered how?
to direct that any specific act of parliament or the state legislature does not apply to a scheduled area or apply with specified modifications and exceptions.
Wow. So the governor can basically say, this national law or this state law doesn't apply here, or it applies, but only in this changed way.
Precisely. That's a truly profound power. It gives immense flexibility to tailor the legal framework.
To avoid laws that might be unsuitable or harmful to the community's specific needs, customs, or social structures?
Exactly. Avoiding that blanket application that might cause disruption or hardship.
And does the governor's power stop there, modifying existing laws?
No, it goes even further. A remarkable delegation of legislative authority. The governor also has the direct power to make regulations for the peace and good government of a scheduled area.
Make new regulations specifically for that area.
Yes, but not unchecked. It must be exercised after consulting the tribe's advisory council.
Ah, the TAC comes in again, ensuring local input into creating these special
It
regulations.
re-emphasizes that importance. And these regulations can be incredibly specific and protective, designed to safeguard vital tribal interests.
Like what? Can you give examples?
Sure. For instance, they can prohibit or restrict the transfer of land by or among members of the scheduled tribes.
Crucial for preventing land alienation, protecting their economic base.
Absolutely vital. They can also regulate the allotment of land to members of the scheduled tribes, ensuring equitable distribution, perhaps aligning with traditional systems.
Okay, land is key. What else?
And very importantly, regulating the business of money lending in relation to the scheduled tribes.
Ah, protection against exploitation by predatory lenders, a historical vulnerability.
A direct measure against that. So it's a powerful set of tools. Land protection, land allotment, protection from exploitative lending.
That's comprehensive. Now, here's a big question. How powerful are these regulations made by the governor? Can they override other laws?
Yes, and this highlights the extraordinary nature of this power. A regulation made by the governor under these provisions may even repeal or amend any act of parliament or the state legislature that is otherwise applicable to that scheduled area.
Repeal or amend an act of parliament. That's significant authority delegated to a governor for a specific area, almost unprecedented.
It is. It allows for truly localized legal reform. But, and this is a critical check and balance, all such regulations require the assent of the president.
Ah, the president's assent is needed, so the center has the final say.
Yes. It prevents overreach, ensures alignment with broader national policy and constitutional principles, maintains that delicate balance between local adaptation and national unity.
Okay. And finally, for the fifth schedule, is there a mechanism to review how all this is working over time?
Yes, the Constitution builds in a crucial periodic review mechanism, commissions on scheduled areas and tribes,
Commissions, appointed by whom?
appointed by the president. The Constitution mandates the president to appoint a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states.
When can these be appointed?
At any time, actually, signaling ongoing flexibility. But it was compulsorily required after 10 years of the Constitution's commencement.
Ensuring an early assessment. Did that happen?
Yes, it did. The first such commission was appointed in 1960, headed by UN DeBar. It reported in 1961.
So early feedback for the new republic on how these provisions were working.
Crucial insights, identifying challenges, suggesting improvements.
And have there been others since?
Yes, though after a considerable gap. A second commission was appointed in 2002 under Dilip Singh Bhuria. It submitted its report in 2004.
40 years between the first and second. That's a long time.
It is. It perhaps speaks to evolving priorities, complexities, and maybe the need for a renewed assessment in a rapidly changing India.
So these commissions provide that vital feedback loop for policy adjustment, keeps the system dynamic.
Exactly. Periodic review and adaptation, ensuring the administration remains responsive. It shows this is a living, evolving framework, not just static rules.
Okay, let's pivot now. Let's immerse ourselves in the sixth schedule. As we established, this covers the tribal areas in just 4 states: Assam, Meghalaya, Tripura, and Mizoram, the Northeast.
That's right. And here, the core unit isn't just a scheduled area, it's a more robust concept, the autonomous district.
Autonomous districts, so the Constitution itself sets these up as autonomous.
Yes, they are constituted as autonomous districts by the Constitution, signifying a deeper level of institutionalized self-governance right from the start.
But how autonomous are they, really? Are they completely separate from the state?
That's a crucial point. While they are autonomous, they do not fall outside the executive authority of the state concerned.
Okay. So it's autonomy within the state structure, not independence.
Precisely. It's a vital balance.
Yeah.
A constitutional tightrope walk, you might say. Significant self-governance, but operating within the overarching framework and executive oversight of the state.
Can you give us the names? Which areas operate under this model?
Sure. The source lists them clearly. In Assam, North Cachar Hills District, Karbi Anglong District, and the Bodoland Territorial Areas District.
Okay. Assam has 3.
Then Meghalaya also has 3. Khasi Hills District, Jaintia Hills District, and Garo Hills District.
Got it. Meghalaya 3 as well.
Tripura has 1, the Tripura Tribal Areas District, and Mizoram has 3, Chakma District, Mara District, and Lai District.
Okay. So a total of 10 autonomous districts across these 4 states, each operating under the specialized 6th schedule model.
Reflecting their unique cultural and historical paths, yes.
Now, what's the governor's role here? Is it similar to the 5th schedule?
Similar in that it's dynamic, but it's specifically geared towards organizational and reorganizational powers for these autonomous units. The governor is explicitly empowered to organize and reorganize the autonomous districts.
Organize and reorganize, meaning what exactly?
Meaning they can increase or decrease the physical areas of these districts. They can change their names. They can define and redefine their boundaries.
So significant administrative flexibility again allows the map to adapt.
Yes, adapt to changing demographics, tribal movements, administrative needs, not fixed in stone.
And does this flexibility go even further? What if a district has multiple different tribes?
Good question. And yes, the Constitution anticipates this. If an autonomous district contains different tribes, which is often the case in the diverse Northeast, the governor can actually divide that larger district into several autonomous regions.
Autonomous regions within an autonomous district.
Exactly. It showcases an even finer-grained approach to autonomy, acknowledging that even within a district, distinct tribal groups might benefit from their own specific self-governing structures.
Wow. Tailoring governance down to very localized, culturally distinct units, recognizing subgroups too.
Truly emphasizing that.
So how does this self-governance actually work on the ground? Who runs these autonomous districts and regions?
It's primarily implemented through powerful local bodies, the district and regional councils.
District and regional councils. Okay.
Each autonomous district has a district council. This is the cornerstone of its self-governance.
And how are these councils formed? Are they elected?
Mostly elected, yes. A district council consists of 30 members. 4 are nominated by the governor, providing that link to state oversight.
Okay, 4 nominated. And the rest?
The remaining 26 are elected on the basis of adult franchise. So a strong democratic foundation ensuring local representation is paramount.
And how long do they serve?
The elected members hold office for 5 years, like typical legislative terms, unless the council is dissolved earlier. The nominated members, however, serve doing the pleasure of the governor, creates that blend of democratic mandate and executive link.
And you mentioned regional councils too.
Yes, each autonomous region, that smaller unit within a district, also has its own separate regional council.
So the self-governance principles extend down to those subunits as well, a multi-layered system.
Exactly. Fostering local control that reflects the intricate social structures of the Northeast. Decision-making really originates from within the communities.
Now, the powers, this seems like the big difference. How powerful are these councils? Are they just advisory, like the tax?
Oh, far from it. This is where the extensive and truly significant powers come in. They are not just advisory. The district and regional councils actually administer the areas under their jurisdiction.
They administer them. They are genuine governing bodies.
Yes. And critically, they possess substantial lawmaking powers. They can make laws on certain specified matters. This is a significant direct delegation of legislative authority, empowering them to create their own legal frameworks
Make laws on what kind of matters?
on matters deeply relevant to tribal life and customs. Things like land, forests, canal water, shifting cultivation, village administration, inheritance of property, marriage and divorce, social customs, and so on.
Wow. Core areas impacting daily life, culture, tradition, allowing them to shape their own laws in line with their customs.
Precisely, rather than having potentially unsuitable laws imposed from outside. But, and it's a vital check again, all such laws require the assent of the governor.
The governor's assent. So ensuring they align with broader state or national principles, that balance again.
Maintains that delicate balance within the federal structure, yes.
Beyond lawmaking, what other powers do they have? You mentioned judicial powers earlier as a key difference.
Yes, significant and explicit judicial powers, a unique characteristic of the Sixth Schedule. They can constitute village councils or courts for trial of suits and cases between the tribes.
Village courts, establishing a local, community-based justice system, using customary laws.
That's the implication. Resolving disputes within the community based on their own practices, fostering ownership over their judicial processes.
And do they just set up these courts? Or do they have appellate power too?
They also hear appeals from them, forming a tiered judicial structure within the autonomous areas, further strengthening local self-governance.
But the High Court can still be involved.
Yes, the High Court's jurisdiction over these specific suits and cases is specified by the governor, maintaining that crucial link to the state's broader judicial system, allowing for higher review if needed.
Okay. What about development? Do they manage local services?
They do. They have developmental powers too. The council can establish, construct, or manage primary schools, dispensaries, markets, ferries, fisheries, roads, and so on in the district.
So like a local government body, responsible for tangible welfare.
Essentially, yes, a full-fledged local government role. And they also have crucial economic regulatory powers. They can make regulations for the control of money lending and trading by non-tribals.
Similar to the Fifth Schedule's intent protection against economic exploitation from outsiders.
Exactly. Safeguarding tribal economic interests. And again, these regulations also require the assent of the governor, reinforcing that balance.
And the final piece for real autonomy money. Do they have financial powers?
Yes, a key indicator of their robust autonomy. They have tangible financial powers. They are empowered to assess and collect land revenue and to impose certain specified taxes.
Their own revenue, so they can fund their own activities.
Exactly, independent revenue generation. Essential for true autonomy and self-governance. Allows them to fund the services development administration they undertake, a critical fiscal foundation.
Now, what about laws coming from outside, from Parliament or the state legislature? Do they just automatically apply?
Similar principle to the Fifth Schedule here. Acts of Parliament or the state legislature do not apply to autonomous districts and autonomous regions or apply with specified modifications and exceptions.
So the councils have a say in which external laws apply, allowing for distinctiveness.
Yes, but there's a key, very nuanced difference here compared to the Fifth Schedule regarding who gets to direct this application. It varies by state.
Oh, how so?
In Assam, the power of direction deciding if a law applies or applies with modifications lies with the governor for both acts of parliament and acts of the state legislature.
Okay, governor decides for both central and state laws in Assam.
But for Meghalaya, Tripura, and Mizoram, it's different. The power lies with the president regarding acts of parliament and with the governor regarding acts of the state legislature.
Ah, so for those three states, the president has a direct say over how central laws apply in these autonomous areas, while the governor handles state laws. That's a very specific distinction.
It highlights a further level of differentiation, specific tailoring for each state. Shows just how granular these constitutional provisions can be in balancing central and state authority over these unique regions.
That's a truly crucial distinction, reveals the fine-tuning, more central involvement via the president for union laws in those three states compared to Assam. Okay, finally, what about oversight? These councils have huge powers. Are there checks?
Yes, The governor maintains a powerful layer of oversight through a commission mechanism and ultimately dissolution powers.
A commission again.
Yes, the governor can appoint a commission to examine and report on any matter relating to the administration of the autonomous districts or regions, a critical review mechanism.
To assess how they're functioning.
Exactly. And this isn't just advisory. If problems are found, if administration is deemed problematic, the governor holds the significant power to dissolve a district or regional council on the recommendation of the commission.
Dissolve the council. That's a powerful ultimate check.
It is a critical check on the extensive autonomy granted, ensuring accountability and proper administration. It shows that while autonomy is granted, it's not absolute. There's a mechanism for ensuring responsible governance. That careful balance is really a hallmark of the Sixth Schedule.
Okay, we've really dug deep into both the Fifth and Sixth Schedules now, explored all those intricate details. Let's zoom out again and synthesize. Compare and contrast these two distinct approaches.
Yeah, pulling it together helps see the overall design, the foresight involved.
It really does feel like a masterclass in adaptive governance for diverse populations. So let's start with the basics.
Geography. That's the most obvious differentiator, isn't it? Immediately signals different purposes. Fifth Schedule applies broadly across many states, mostly peninsular India. It's widespread.
Right. While the Sixth Schedule is exclusive, laser-focused on just those 4 northeastern states, Assam, Meghalaya, Tripura, Mizoram.
That geographical separation immediately tells you there's a different philosophy, different circumstances, needing 2 separate tailored approaches.
And that leads directly to the core rationale, the why behind them, which seems like the most profound difference.
Absolutely. For the Fifth Schedule, the primary constitutional reason is it recognized social and economic backwardness of the tribal populations in those areas.
So the intent is primarily welfare protection, upliftment.
Yes. Recognizing disadvantages, needing special efforts, administrative adaptations, legal protections to improve their condition, integrate them developmentally while respecting their ways. It's fundamentally a protective and integrative model.
Okay, protective integrative. Now, contrast that with the Sixth Schedule's rationale.
It's rooted less in economic backwardness, though, that might be there, and far more in that profound recognition that the tribes in the Northeast have not assimilated much.
Right. They've maintained their roots in their own culture, customs, and civilization, unique cultural integrity.
Exactly. So the emphasis isn't just upliftment. It's fundamentally about preserving these unique cultural identities, languages, traditions.
And that distinct cultural integrity is why they get that sizable amount of autonomy for self-government.
Precisely. It's not about assimilation into a larger fabric. It's about enabling a unique, robust form of self-rule, allowing them to thrive while maintaining their distinct heritage. It's a preservationist and self-determination model.
Preservationist, self-determination, that's a clear contrast. And this difference in rationale directly impacts the level and nature of autonomy, doesn't it?
Absolutely. Under the Fifth Schedule, yes, there's special protection. The governor has significant powers to adapt laws. The center has somewhat greater responsibility.
But the tribe's advisory council is primarily advisory.
Right. It's a system mainly designed for protection, preventing exploitation, ensuring administrative oversight for welfare and development within the state framework. The state's executive power largely still extends, just with social provisions.
Whereas the Sixth Schedule delivers, well, it seems like a much more revolutionary form of self-governance.
Significantly more robust, yes.
Yeah.
You have the district and regional councils, not advisory, but real pillars of self-rule.
Wielding extensive legislative, judicial, administrative, financial powers.
Making their own laws on core subjects, running village courts, managing local development, collecting taxes. It's fundamentally built around genuine self-government and self-determination, a remarkable degree of autonomy within the state framework, almost like mini-governments.
Following from that, the lawmaking authority also differs significantly.
Definitely. Fifth Schedule. Legislative power for the area mainly rests with the governor making regulations, modifying laws, but needing presidential assent or consultation. The governor is the key legislative actor for adaptation.
Okay. Governor-centric adaptation. Sixth Schedule.
The power to make laws on specified subjects rests directly with the district and regional councils themselves. They are the primary legislative bodies for their areas.
Shaping their own legal landscape on land, marriage, customs.
Yes. That direct legislative power from elected local bodies is a hallmark of the greater autonomy. Although their laws need governor's assent, the initiation, the drafting, lies with the councils.
And we noted the difference in applying external laws, too, with the president involved for union laws in some Sixth Schedule states.
Yes, that layered system of checks for external laws also marks a difference.
And the judicial powers. That seemed like a very clear distinction.
It is. The explicit power to constitute village courts hear appeals that's prominent and direct in the Sixth Schedule councils, administering justice via customary laws.
While the Fifth Schedule focuses more on protection through regulations made by the governor, it doesn't grant that direct, formal judicial authority to a local body like the TAC.
Exactly. The Sixth Schedule demonstrates a far greater degree of judicial self-determination vested in the autonomous councils.
Lastly, the relationship with the center and state. Oversight exists in both, but it works differently.
It does. Fifth Schedule. Center has somewhat greater responsibility, gives executive directions, governor reports annually to the president. It's shared but centrally guided responsibility.
Yeah, the Sixth Schedule.
While state executive authority still exists, the self-governing councils have a much more direct relationship with the state via the governor assent for laws, dissolution power.
And that varied authority for applying central laws involving the president directly in some states.
Shows how finely tuned, how state-specific the balance of power is within these truly autonomous regions. Reflects the unique status of the northeastern tribal areas. Hashtag tag outro.
Wow. We've really journeyed through two incredibly detailed, distinct, and frankly, profoundly thoughtful constitutional systems today.
Meticulously designed to administer and protect India's scheduled and tribal areas.
From the president's power to declare a scheduled area, the governor modifying laws in the Fifth Schedule,
to the robust self-governing autonomous councils of the Northeast through the Sixth Schedule, with their own legislative, judicial, financial powers. We've seen firsthand how India adapts its governance to its immense diversity.
And understanding these unique structures, it's not just constitutional trivia, is it? Not just dry legal text.
Not at all. It reveals this profound, enduring commitment to equity, cultural preservation, and decentralized governance.
Yeah.
In a country constantly navigating immense diversity.
It's a living testament, really, to how a nation strives to uplift vulnerable communities, protect them, empower them to shape their own futures.
All while simultaneously respecting their unique identities, customs, ancient traditions, providing a framework for genuine self-determination within the larger federal structure.
So as we've seen, the Constitution provides for truly significant autonomy, special protections, creating this mosaic of governance within one nation.
It does.
And this raises, I think, an important question for you, our listeners, to consider, something to mull over. How does maintaining such distinct, varied administrative systems within a larger national framework, how does that contribute to, or perhaps even challenge, the idea of national integration and uniformity?
It's a deep question.
What are the long-term implications, positive and complex, of granting these varied degrees of self-governance? And how does a country continuously balance that inherent need for both unity and diversity, for both integration and distinct identity?
It's a question right at the core, isn't it, of what it means to be a modern, diverse nation, something to really think about.